Hear ye, hear ye, hear ye. The Honorable Chief Justice and Justices of the Supreme Court of Ohio. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
Good morning, ladies and gentlemen. Our first case this morning, it's our only case today, is 2021-1428, Regina C. Adams et al. Versus Governor Mike DeWine et al. And 21-1449, the League of Women Voters et al. Versus Ohio Redistricting Commission et al. For the relators, we have Mr. Stafford arguing for 15 minutes, and I believe then we will have Mr. Fram for the remainder. Is that correct?
Your Honor, I anticipate taking 12 minutes. Mr. Fram will take 12 minutes. We'll reserve 6 minutes for rebuttal, 3 for myself and 3 for Mr. Fram.
All right, watch your time.
Thank you. May it please the court. Happy holidays. Ben Stafford on behalf of the Adams Relators. Today I'll be addressing first the Article 19, Section 1C3 standard and how on a plan-wide basis the 2021 plan unduly favors the Republican Party. And second, how the extreme partisan bias of the plan is not warranted by Ohio's geography. Mr. Fram will then address the 2021 plan at the regional and district level. In 2018, Ohioans voted by overwhelming margins to amend the Constitution to limit the General Assembly's power by adding new rules governing congressional redistricting. Of relevance here, where the General Assembly passes a plan without bipartisan support, the plan is subject to additional anti-gerrymandering limitations set out in Section 1C3 of Article 19. First, the plan cannot unduly favor or disfavor a political party or its incumbents. Second, the plan cannot unduly split political subdivisions. Third, the General Assembly must attempt to draw compact districts. This sweeping reform came in response to the 2011 redistricting cycle, when the Republican majority enacted a plan that persistently elected 12 Republicans and 4 Democrats, even while about 46% of Ohioans voted for Democrats in statewide races over the course of the decade. This case is about how the General Assembly has thumbed its nose at these reforms and enacted a plan that palpably violates Article 19's new anti-gerrymandering protections. Start with the rule of decision. This is provided by the text of Article 19, Section 1C3A. It provides a mandatory thou shalt not standard. A plan shall not unduly favor or disfavor a political party and its incumbents. There can be no suggestion that this section sets out mere aspirations that can be disregarded at whim, as the court heard in the General Assembly case. All parties agree what undue means. It means unwarranted or excessive. So the standard requires a baseline. Unwarranted or excessive compared to what? Well, what would happen if partisanship wasn't taken into account in drawing a plan? And there's a couple of different ways that we can measure this. First and briefly, courts have used mathematical analyses measuring the partisan bias of a plan, tests such as the efficiency gap. Relators applied those tests here, and as laid out by Dr. Warshaw and Dr. Roden in detail in their reports, these measures all show that the 2021 plan has an extraordinary partisan skew, on par only with maps making up the national rogues gallery of extreme partisan gerrymanders in recent years. And respondents have offered no rebuttal to any of that evidence. Second, an even simpler way of thinking about partisan bias is to take how people actually vote, not as the final analysis, but as the starting point. How do people vote? About 53% of Ohioans voted for Republicans in statewide races over the past 3 general elections, about 47% for Democrats. Or again, over the whole decade, it's more like a 54-46 split. By contrast, relators have shown that Republicans are favored in at least 12 of 15 districts in the 2021 plan. That's 80% of the seats. A plan where one party is favored to win 80% of the seats when it only wins 53 or 54% of the vote clearly favors that party. So the question under Article 19 is that favoritism undue? Is it unwarranted? Proportionality gives us a starting point. Lack of proportionality between votes cast and the outcome evidences undue favoritism. Because when a plan is disproportionate, one of two things is going on.
Mr. Stafford.
Yes. Oh, apologies.
Oh, it's all right. It's the vagaries of the technology. Deciding which database to use, deciding which elections to use, unlike the legislative redistricting, is not prescribed by Section 19 of the Constitution. So is the question of which databases to use, what years, is that a policy question that's for the legislature, or is that a question of law that we should be deciding, or should it be based on the evidence? What kind of standard do we set?
Ultimately, the court can look at the evidence in this case, and regardless of what particular measure or metric one utilizes, the bias of the plan remains the same. And we can see this if we run simulated maps, if we look at these measures of efficiency. And so any questions about which data to use really ultimately may go to how much bias is in the plan rather than whether the plan unduly favors one party or the other. But in this...
But I want to get specific on the evidence, because Mr. DeRossi had 2 different databases that he had the option of using, or depending on how he was being directed by his superiors. One was the FEDEA, a federal election database, for 10 years. And then there was the EA53 database, which was statewide elections for 2016 through 2020. And some of the experts said if the latter database, the state elections for 2016 through 2020 were used, it was a little better outcome for the Democrats than if using the federal database. So, I mean, what is this court to do about that issue?
Well, what the record evidence shows in this case is that behind the scenes, Mr. DeRossi was in fact considering data that's more fulsome, that has more election results, that's actually more predictive of election results. And what was disclosed publicly was this cherry-picked measure, a measure designed to make the plan look more competitive than it actually was. So a different case in the future might present a different question about why the General Assembly was relying on one measure versus another measure. In this case, the record clearly shows that what was being done was an attempt to bolster the competitiveness of the map, or the apparent competitiveness of the map, when in fact they were looking at different metrics behind the scenes.
But isn't past election data, it's somewhat questionable about how it will predict the future, but it's probably the best we have. And so is that an assumption we can make, that we can at least start with using past election data?
We absolutely can, and that's what the parties are doing here. And we should be skeptical of a measure that's only looking at federal data, that's not actually very predictive of the results of the elections at issue here, where 1/3 of the results is the 2012 election, almost 10 years ago now. So the particular measure that they have attempted to rely on is clearly spun or skewed to attempt to achieve a particular outcome. But we do look at past election results.
Mr. Stepp, to be fair, what I heard your experts saying was, well, this is unfair because it doesn't count the 2014 election, which was an election which was kind of unlike any other in Ohio, and we had a Democratic governor's candidate who got 32% of the vote because he didn't have a driver's license. I mean, why is that necessarily more fair to include that than elections that are more representative of what Ohio has?
Well, Dr. Roden actually relied on 2016 to 2020 data as a more recent snapshot that's more predictive.
Well, but I think a couple of your other experts were talking about this data set that in fact, what they said over and over again in their affidavits was that it was incomplete because it didn't include this 2014 data. And to me, I mean, I'm not sure which data set is best. I don't know that court can pick that, but it doesn't seem immediately obvious to me that including several statewide elections in a year that was completely abnormal, probably the most farthest from the norm we've had in Ohio in the last couple of decades, would make the data a lot better.
It wasn't just 2014, it was any statewide election in any year. So if we look at the entire data set of the past 10 years, again, it shows that this federal only measure that they were relying on was particularly skewed. If we look at 2016 to 2020 data, we see the same thing. And again, regardless of the particular measure that we use, the plan cannot be explained by a nonpartisan metric. And what I mean by that is that the gross partisan slant of the 2021 plan, regardless of what data one's looking at, is unwarranted by Ohio's geography. And we showed this in various ways. Perhaps most notably, Dr. Amai ran 5,000 simulated maps. Each complies with Ohio's constitutional requirements and reflects the state's political geography. Each of these maps is at least as compliant with all of Article 19's restrictions to the 2021 plan. Dr. Amai then assessed the partisan outcome of those maps using exactly the same electoral index respondents rely on. Of the 5,000 maps he generated, exactly zero have the same level of pro-Republican bias as the 2021 plan. In fact, the average of maps in this 5,000 map set had nearly 3 fewer Republican favoring seats than the 2021 plan. And Dr. Amai concluded that there's simply no chance that the expected Republican seat share under the enacted plan could occur absent partisan bias. And notably, this evidence stands completely unrebutted. Respondents' brief will be searched in vain for even a mention of Dr. Amai's name, let alone a rebuttal of his analysis. They
And
simply
so
haven't.
Are you reading the proportionality aspect in Article 11 into 19? Because proportionality to the statewide populace, while the General Assembly, when they wrote these joint initiatives for the citizens to vote on, could have included what is in Article 11, it's not in Article 19. It's unduly burdensome. It's that unduly excessive language. So I'm hearing that you want to read that provision in 11 into 19, but it doesn't exist. And we knew that they knew how to write it because they put it in 11. That's part one. Part two, if you look at Ohio's elections and you look at your own data sets, more people turn out in Ohio to vote in federal elections than in other statewide elections, by and large. So because this is a federal election, why wouldn't you want to be looking at the data set that is commensurate to what you are trying to measure it against?
To take the second question first, that's not what the respondents did here. They looked at the Senate and President turnout, not congressional turnout. So they weren't looking at endogenous elections. They just cherry-picked which exogenous elections they looked at. In terms of the first question, no, the standards are different. So there is a strict proportionality standard. One has to achieve proportionality if one can under Article 11, Section 6B. That's not the case under Article 19. It is a different standard. But proportionality gives us a starting point to look at. But the simulated map analysis that I was just describing, that's not reliant on proportionality. That's just looking if one drew the plan without attempting to achieve partisan outcomes, what would happen? And it would result in about 3 fewer Republican-leaning seats than under the 2021 plan. And again, the respondents don't respond in any way, shape, or form to Dr. Amai's analysis, which starkly illustrates that respondents' geography made me do it explanation is an excuse, not an explanation for the 2021 plan. And then one final point is that in assessing whether the plan is unduly partisan, we have one final very obvious point of comparison, the 2011 plan. Republicans won 75% of the districts in the 2011 plan that got struck down as a partisan gerrymander. The current plan favors Republicans in 80% of the seats. If the 2018 amendments mean anything, they don't permit that. You can't go from a 75-25 Republican slant to an 80-20 slant. You can't take the status quo and maintain it, let alone favor the Republican Party even more. But that's what the 2021 plan does. So the fact is that it is undeniable that there is a violation of Article 19, Section 1. I'll turn it over now to Mr. Fram to address how the plan's undue partisan favoritism manifests in particular line drawing decisions throughout the state.
Thank you.
Chief Justice O'Connor, and may it please the court. I'd like to address the story from the ground up regional level, a couple of examples, and also discuss a little bit this question of the standard, what it means to be an undue favoritism for a political party that was just recently discussed just now with Mr. Stafford. On the question of the regional bias, I won't go through everything that's in our reply brief. We have pages 7 through 11, where we go through a whole series of regions, 4 in particular, in particular, Hamilton County, Summit County, Franklin County, and up near Toledo, and how the districts were drawn. But I would like to look at 2 as an example. And with that, I'd like permission for the court to share my screen to show one of the maps that's in our reply brief, already part of the record. It's Chen figure 14A. I hope that is figure 14A is now visible to the court.
Yes, it is.
Thank you, Your Honor. A few observations regarding these maps. The left is the actual enacted plan. Figure 14B on the other side makes a point based upon Dr. Chen's simulations. But under the enacted plan, what we see is that Hamilton County, of course, a chunk of it's carved out and it's attached to Warren County. It's notable because under the Constitution, a provision was passed so that Cincinnati would be kept whole. This is part of the provisions in Section 2. And the assumption there is, of course, that with the Cincinnati voting strength leaning, that you would wind up with a Democratic leaning district. That was
Well,
avoided.
let me ask you about that.
Sure.
In this district, President Biden got the majority of the votes in that district, won that district in the last election, right?
That's right. Yes, Your Honor.
So that would seem to say it's a pretty competitive district for Democrats.
He did, Your Honor. However, what we have here is, if you look at the actual scoring, it looks like the Republicans, by the way, this has now been redrawn. It's a little different than the 2011 map, so the piece of the chunks are different. And what we see here, Dr. Chen, you've got about a 51.6% Republican advantage. If you didn't pull that chunk out of Hamilton County,
but again, I mean, I get that that's his score, but if we look at the most recent election, which would seem to be pretty predictive, you would have, I think, a 51.5%, 52% Democrat advantage, at least based on the presidential election.
If you pick just one election, Your Honor, if you look at a broader number of elections, everybody seems to agree that that's appropriate. What one winds up with seeing that you get a very substantial Republican advantage by adding Warren County in there, and not including all of the.
Mr. Fram, I thought that Dr. Chen said that there were many counties that his analysis was there'd be about 12, 14 counties divided up in all his programs.
There are many different, different counties, different elections. There are different, he has different, this is simulated map 639 from Chet.
I understand, but his overall analysis was you're going to have some counties broken up, period.
Oh, understood, Your Honor, that you can't have counties.
And to be clear, you can't do this without breaking up at least 14 county divisions, correct?
But there's no, overall for the statewide, yes, Your Honor, but for this particular situation, there's no requirement to break up Hamilton.
But so if you get rid of one divide in Hamilton County, you have to divide another county somewhere to compensate for that, right?
Yes, Your Honor, and that is true. However, the question has to be how compact or not compact will the resulting districts be? And one thing we see here in this comparison is the substantial difference in the compactness between the two different options we're looking at here. In other words, the core point in thought here is that non-compact districts were created for the goal of partisan gain. Compactness is an objective. It has to be attempted under section 1C3C. Has to be attempted. And when we see a substantial deviation from compactness that results in a substantial increase in partisan gain, that's a tip-off that what we have here is an unduly favoring of one political party. And that's, so it's we're not talking about the sheer number.
Isn't your burden here beyond a reasonable doubt?
So the question here on beyond a reasonable doubt is, we believe this was not contested, that there are these options, that it's really not a concern. We can meet that standard if we need to. We don't think we should have to, given that there aren't conflicting provisions of the state constitution, as was the question in Wilson v. Kasich.
This is a facial challenge, correct?
Yes, it is, Your Honor.
And that would demand a beyond a reasonable doubt standard under Ohio law, correct?
Well, let me be clear. It's facial in terms of how they did it. In a sense, it's uncontested, the facts. As it's also as applied, Your Honor. But in this case, it's the two collapse. The two collapse because the facts here are uncontested.
But if your own expert is saying, if I don't chop up this county, I got to chop up another county, doesn't that show two plausible results?
No, Your Honor, I would suggest it does not, because it's not a question of the number of splits that are at issue. The question truly has to do with what the way in which the splits are done, whether they're done in a way that violates the compactness objective. It is not simply a question of adding up total numbers of splits and say, well, if you have to come up with the same number of splits, it doesn't matter.
Splits do matter under our Constitution, correct?
They do, Your Honor, Section 2.
Thank you.
They do, but it's just, our point here is that they did the splits in a non-compact way. Perhaps an easy way to see that also is if one looks at, scroll down also on our reply brief, at what was done here in around Akron. And here's the example of the kind of splits we're talking about in terms of how problematic it is. What we've got here is in the Akron area, looking at Summit County, it was split up so as that the eastern part of the county goes down into District 7, which goes, of course, pretty far south down to Wayne and Holmes. The western part of the county is included with Medina in District 13, a heavily Republican region. The northern part, where you might have gotten some votes out of southern Cuyahoga County, is included in District 14, which is notable in that the western and the eastern part of the district are connected by just one census block. And so what you've got there is they've siphoned off the Democratic votes into 14, and they've submerged them in 13 and 7. So instead of having a Democratic leaning seat in the Akron area, the way the split was done was so non-compact, and the expert reports are all there in the record on the non-compacted scores, that's what created the problem here. It's not merely the number of splits, it's the way you split them. And
so that created a District 13, where President Biden got what percentage of the vote last time?
I don't know, Your Honor.
It was,
I don't have that number.
it was 50% or very close, wasn't it?
I believe, I know former President Trump carried the Medina County by a very large number.
But that's not really the question.
I don't know the whole
right?
District 13, but District 13 again didn't exist at that time in this shape.
But if you looked at those precincts, who would have won that district? President Biden or Trump?
I don't have that number, Your Honor.
So let me ask this question: with all the experts in the map drawing and the software programs, was there a map drawn by anyone that did not consider partisanship at all? Just drawing numbers and breaking counties or compacting or drawing in a way that just simply made sense based on the voting population or the geographical boundaries of the counties.
Dr. M.A.'s 5,000 maps did not use partisanship as a basis for drawing the maps. He evaluated the maps in light of what the partisanship looked like thereafter, after he drew them, but he did not use partisanship as his criteria, if I understand Your Honor's question.
Okay, and all other maps drawn did use partisanship.
In actuality, we know that the maps that were drawn looked at partisanship because we know that Mr. DeRossi and Mr. Springhetti had their partisan indicia on their data view, and they can see every time a map changed what the result was. I believe the question was raised before as to whether one should consider the 2014 race or not. Mr. DeRossi's index, EA53, in fact, did not look at 2014. It was 2016 to 2020. And that also showed was much more clearly had stronger Republican strength than did the publicly disclosed federal index, the cherry-picked index that they used to justify the map. So one doesn't have to go and include 2014. Mr. Springhetti did, which also they did not disclose. That was EA51. But one doesn't have to go that far to see the partisan skew.
Mr. Fram, does it matter where the data comes from? Because some of the issues in the earlier litigation on legislative redistricting were that the data was difficult to obtain, and so it was actually obtained from the legislature's consultant out of Virginia, and it didn't seem like Mr. DeRossi really understood where it came from. It just got plugged in because there are a number of factors that have to go into actually putting it into a usable database for everyone to use. Here for the federal, it sounded like it all came from the Secretary of State because it was statewide elections. But I mean, should we be concerned just now and for the future, just where this data came from?
Your Honor, I agree with the concern. There are issues while the data in gross for elections can go back through the Secretary of State's office, getting particular precincts is sometimes problematic, as was clear in I believe in the record in the General Assembly case. In this case, outside consultants were apparently used, but when we asked in Mr. DeRossi's deposition as to what came from the consultants, there was an instruction not to answer the question. And so that is not part of the record here.
Well,
They
that was
asserted
because of-
attorney-client privilege to block that information.
Was that because of legislative privilege or attorney-client?
I believe the consultant instruction was based upon attorney-client privilege, Your Honor. It may also have been legislative privilege, but I believe it was primarily they were asserting that these consultants were agents of counsel.
Thank you.
I'd like for the few minutes I've got left just to talk a little bit about the standard. I won't repeat what Mr. Stafford said. We agree that proportionality is the starting point under unduly favor. And then the question then becomes, what does unduly mean? Well, I'll stick with the respondent's definition of unwarranted. They cite to the Black Dictionary, from which we translate as being simply unnecessary. There seem to be two ways that a deviation from proportionality can be necessary. And one would be compliance with other provisions of Section 2, and the other would be, say, Article 19, and the other would be by geography. MA's 5,000 maps fully comply with Article 19, Section 2. They fully take into account geography. They clearly rebut any notion that the deviation from proportionality was warranted. What does that mean? It means that if one looks at the deviation from the compactness goal, which is a textual basis for looking what's undue here, and one sees that they drew maps that deviated from compactness, that's another reason to be very clear this was undue. They both, in terms, it was not necessary from geography, it was not necessary for Section 2 of Article 19, and indeed to the contrary, it was violating the compactness objective of Section 1. All of that, Your Honor, we submit made this an unduly partisan map. With that, Your Honor, I'd like to reserve my time.
Thank you. All right. Just so you're aware, I'm looking at the clock, and I think that there's, if I'm not mistaken, less than a minute that has been reserved here. All right. Our next, for the respondent, Mr. Spratt.
Thank you, Chief Justice O'Connor, and may it please the court. This case is about a congressional district plan that fully complied with Article 19 of the state constitution and was the most constitutionally compliant of all the plans before the General Assembly. The other plans before the General Assembly split more counties and other jurisdictions than the enacted plan.
Also, let me ask you a question. You say it was the most, appropriate map before the General Assembly. Did I hear you right?
Yes, Your Honor.
Okay, but does that mean that just because it was presented to them, that would be the only, that they had to consider only that? They couldn't look at it, give directives to, maybe make adjustments to that map? Are you saying they had to vote on the map that was put before them?
Your Honor, when I say before the General Assembly, I'm saying that in the sense of the plans that members actually submitted and put forth for consideration by the General Assembly. The Democrats put forth two plans. Senator McCauley had a plan. His is the one that ultimately got enacted. I believe the House also had a plan. House Republicans had a plan. So I'd say that in that sense, certainly the legislative members could have looked at other plans. And frankly, if the relators in this case, they could have presented this simulation analysis and all these other computerized plans to the General Assembly during the process. And the General Assembly certainly could have taken that into account. Unfortunately, they did not do that. And so this is similar to the Wilson v. Kasich case, where the court decided that a map submitted after the fact was really not very helpful to the court in assessing the plan, because the relators there didn't give the General Assembly a chance to see that map. And so of all the maps that were...
But counsel, if the map that was, the plan that was adopted is demonstrated to be violative of compactness or any of the other components that need to be considered here, are mandated, I guess, here, It wouldn't matter what the alternative plan was of any one of these 5,000 alternative plans. Would you agree with that?
Certainly, Your Honor, if the enacted plan fails to meet the standards of Article 19 as articulated by this court, certainly that's the end of the story. But my point is that.
So it's not the end of the story. It's go back to the drawing board.
Well, that's correct. That's correct. And as last oral argument that we had, that could be a process that could go on for quite a bit, and one which the federal courts could ultimately take over. But
Chief, excuse me, I'm still looking at the shared screen from Relators. Could we?
Oh, I meant to say that. Yes, thank you, Your Honor. That's much better.
Mr. Strack, may I ask a question?
Yes.
Your friends on the other side, they make a point to raise that in your briefing, you did not even address Dr. Amai's conclusions in his report, in which he found that the enacted plan arbitrarily and unconstitutionally split Hamilton County twice, placing that county's territory in 3 different districts, specifically splitting communities of interest, namely the Black community in Hamilton County. Why was this necessary, and why did you not address Dr. Amai's conclusions?
Your Honor, it's a fair question. We addressed the computer simulation evidence in general. We think it's deeply flawed because at the end of the day, the computers draw what a human being tells it to draw. And so if you don't tell the computer to use criteria that match what the General Assembly actually used, then what it will spit out is really just garbage. It really is meaningless for certainly any legal analysis. And here, Hamilton County was split the way it was because there was an attempt to join it with a whole county. There's a provision in Article 19 that specifies that where you can, every district should have a whole county. And so here, Warren County was the county that was chosen to be joined with Hamilton County. Now, reasonable people can disagree about whether that's a good idea or whether that should have been done. But under the Constitution, it clearly was allowed because the Constitution says, and it's very specific about this, it says you can split 23 counties. Very few constitutions are like at that level of granular detail on what you can do and not do. And it goes on to say that you can split 5 of those counties twice. And so, and let me, in answering your question, let me point to some other language in that provision that I think is very relevant to Hamilton County and the other counties that were in fact split. Section 2B5 says that the authority drawing the districts may determine which counties may be split. As we read that, that is a direct grant of authority to the map drawing authority to split whichever counties they want to split, so long as they don't split more than 23 and they don't split more than 5 twice. Here, only 2 counties were split twice. The General Assembly could have done 5, and they only did 2. And so at a minimum, all these simulation experts should have run simulations based on a rule that would have allowed 5 counties to be split twice.
Mr. Strack, does that override the requirement to protect minority voting rights?
There's been no claim, Your Honor. Obviously, federal law would trump that provision of the state constitution. I'm not aware of any claim that's been made that district in Hamilton County violates federal law. And of course,
nowhere in Mr. DeRossi's deposition did he even discuss having to factor in minority voting rights. So what would be the percentage of racial balance that's needed in a congressional district to achieve the protection of minority voting rights?
So, Your Honor, under the voting right, under the 14th Amendment to the U.S. Constitution, if the General Assembly had considered race to try to draw that district to a particular racial target, that would be considered racial gerrymandering under federal law, unless there was a sufficient reason under Section 2 of the Voting Rights Act to draw that district. And under federal voting rights law, that means that the jingles preconditions would have to be met, which would mean at a minimum, there would have to be a Black population of at least 50% in that area that could be combined into a district. And then you'd have to go on to show polarized voting, et cetera. There's been no showing in this case, no allegation by anyone, even in the legislative process, that such a district could have been drawn. And so using race in Hamilton County would have violated federal law in this case, and that's why it wasn't done. And so the minorities in Hamilton County have been afforded all the rights under federal law to which they are entitled in the drawing of these districts.
Also, you talked about the 23 counties that can be split twice. That's permissive. It's not. You're saying that wasn't done. So you're saying it's not. It's almost like you're saying it's not as gerrymandered as it could have been.
Your Honor, I'm just saying that the Constitution allows 5 counties to be split twice. So the General Assembly could legally have done that.
But could they do that for partisan reasons?
They could do that. Well, they could do that. Whether it was for partisan reasons would have to be borne out in whatever map that we were looking at the time.
Could they? I'm saying they could just split counties 5 times. They could split up to 23 counties. But can those splits be for partisan reasons?
Well, Your Honor, the Constitution says that the districts cannot unduly favor or disfavor a party or its incumbents. It doesn't say you can't draw districts with partisanship in mind. So certainly partisanship could be used. It just couldn't be excessively so, which is what that language is saying. Here,
so you're equating excessive and unduly?
Yes. Yes, Your Honor.
Okay, so they can make these splits using partisan reasons, but if they do use partisan reasons, those partisan reasons, that partisanship can't be unduly, and which I think everyone agrees means unwarranted. So how is that measured? How is the warrantedness or the unduly part of it measured?
It's a fair question, Your Honor. It's a very difficult question, and we think it's not defined in the state constitution.
Okay, not then how is it measured? How do the map drawers measure whether or not their partisan drawing is average, unduly, minimal?
Yes, Your Honor. I'll tell you how the map drawers and the map drawing authority did it in this particular case. They avoided drawing unduly favoring or disfavoring a party or the incumbents by intentionally drawing 7 competitive districts. They made sure, as our brief points out, everybody agrees that in Ohio, you're going to have 6 strong Republican-leaning congressional districts. You're going to have 2 strong Democratic-leaning congressional districts. The question is, what do you do with the 7 that remain in the areas of the state where you have some discretion about how much of a lean to draw the district? The General Assembly here could have reasonably said, you know what, the current map is a 12-4 map. There's 12 Republican incumbents, 4 Democratic incumbents. And so we don't want to disfavor the Republican incumbents. So we're going to take those remaining 7 districts and draw 6 strong Republican-leaning districts if we can, because that would match the current number of Republican incumbents. They didn't do that. They took a much, I think, much better approach, one that benefits the citizens. And they said, no, we're going to draw 7 competitive districts. And so they drew these districts within a range of 46 to 54%, which the court is very familiar with. It's been hearing a lot about recently. And look, there are various ways to measure how is a district competitive. There's no doubt, and Justice Bruner's questions about election data, I think, sort of get to the heart of that question. And it's very difficult for, frankly, experts and lawyers and judges to try to adopt a constitutional rule that sort of imposes a definition. But here, what's interesting is the General Assembly says there's 7 legit competitive districts. And even the plaintiffs' experts get pretty close to the General Assembly. Dr. Rodden, if you look at a plus or minus 5% range under his data, he gets 6 competitive districts. Dr. Chin at figure 19 of his report, I count 6 competitive districts within that range. There's a popular redistricting app called Dave's Redistricting, and it scored the Ohio congressional map, and it gave it 6 competitive districts. So what I think is just undisputable here is that it's very clear that the General Assembly decided not to unduly favor or disfavor anyone by drawing districts that were going to be competitive. These districts absolutely can flip back and forth in the coming decade. If the Democrat, there are several Democratic leaning districts. If the Democrats recruit good candidates and run on the right issues, they can absolutely win those districts, and they can absolutely win the Republican leaning competitive districts. The same is true for Republicans. If Republicans recruit good candidates and run on the right ideas, they can absolutely win those competitive districts too.
The thing that I'm concerned about is that in the briefing, it's presented as a 4-point plus or minus difference when we're talking about competitiveness, if that's even appropriate, because it's not in the constitutional section we're concerned with, but that's actually an 8-point spread. What's the basis for coming up with I can't find any basis in any of the briefing that where this 4-point plus or minus, what's that supported by evidentiary wise, factually wise, other state law wise? Where do we come up with that?
Thank you, Your Honor. I mean, again, these are all disputed. I mean, not even the political scientists agree on this. What the General Assembly here did is relied in part on public testimony, and there was witnesses from a group called Fair Districts Ohio who testified that plus or minus 5% would be fair.
Okay,
Some people
go ahead.
I'm sorry, Your Honor, it was all over the map. Some people said 5%, some said 4%, some said 3%. And so the General Assembly simply said, well, 4% seems to be in the range that's within the range of what other people are saying. So we're going to use that. And of course, as you know from the last case, the statewide vote share, everyone seems to agree that that's 54-46. So that seemed to make sense from that perspective too.
Thank you. And on the public input, here's one thing that really bothered me. 1H of Article 19 requires the legislature to pass a law that basically tells people, the public, how they can submit proposed congressional district plan maps. So the first deadline was for the legislature, and that was September 30th. But they didn't pass this law until September 29th, one day before. So how did these groups like Fair Districts Ohio or whoever, how did they know how to submit a planned map if they only got the rules a day before the deadline for the legislature, before it flipped over to the Redistricting Commission?
It may be a fair point, Your Honor. I don't really know the answer to that question. I do know that many people submitted congressional plans. So whatever the effect of passing that law when it was, it does not seem to have stopped people from being able to submit many plans.
Thank you.
So we just think, and Justice Brunner, the question you raised, the word competitive, it's not in the Constitution. Nor what I might add is the concept of proportional representation, which my friends have referred to on the other side, and they say that proportional representation should be, quote, a starting point. I have no idea what that means. I don't think anybody knows what that means. I don't actually think they even know what that means. What does that mean? Does that mean that the General Assembly would have to look at proportional representation and then hire a computer simulation expert to draw the right districts? Should we just turn redistricting in Ohio over to computers and say, computer, you draw the map? I don't think that's what anybody wants.
Can't the maps just be drawn based on the geography of the state without partisanship being included at all for either side, and let the chips fall where they may?
Your Honor, in many respects, that's what was done here. The reason they used data was to make sure, this is a brand new constitutional provision, says you can't unduly favor parties. And so I think it made sense to them to make sure they were using data to draw competitive districts. That's how they chose to do it. Yes.
But the part that says without unduly favoring or disfavoring a party, if they're drawn without partisanship being taken into consideration, how does that favor one or the other or disfavor if it's not even considered?
Your Honor, I can assure you, I would, in North Carolina, we don't use election data anymore. And that's a perfectly permissible and fine approach, and frankly, one that may be used in the future. I don't know, but I can assure you, Your Honor, that if the General Assembly had drawn the districts without use of any election data, based on the political geography of—
I'm sorry if I misspoke by election data. I mean partisan data, partisanship.
Correct, and that's what I'm referring to, use of election data. Using election data to score the districts, to decide what the district should be, that's how that is actually done. And what I'm saying is, if the General Assembly here had not used election data to try to create competitive districts, and instead had just drawn it without data at all, and just purely based on geography, I can assure you we would still be standing here. And I can assure you a lawsuit would still be filed alleging that somehow the Republicans had secretly done something, because it would produce a Republican map. That draw without data would produce a Republican map based on the political geography of Ohio. And we would be right back here. And so what the General Assembly decided this time was, look, we're going to be sued no matter what. And so we're going to make sure that we draw competitive districts. And this is what's interesting about that. The people of Ohio voted in, the General Assembly proposed this amendment. The people of Ohio voted it in, and they wanted less partisanship in the districts. And that's absolutely what they got. Now, reasonable people can disagree about what the General Assembly did here in terms of the outcome, but the districts are a win for the people of Ohio. They got more competitive districts. 7 out of 15, that's a plurality of the districts are now legit competitive districts. Many of even the experts agree, and to that point, our expert and another source points out that Senator Sherrod Brown would have won 8 or 9 of these districts. That to me is very telling. Senator Brown's obviously a Democrat. That to me is very telling, because what it says is there are a lot of competitive districts in there. They were intentionally drawn that way, and if Democrats recruit the right candidates like Senator Brown, they run on the right ideas like Senator Brown, then they can absolutely win the same districts that Senator Brown seems to be carrying in these elections. And so I think the reforms absolutely worked. It caused different decision-making on the part of the General Assembly, rather than saying, hey, we're going to try to draw 6 more strong Republican districts. We're going to legit draw competitive districts and let the chips, as Justice Stewart, as you say, let the chips fall where they may. Let's see how the elections go. Let's see what the political dynamics play out and what the U.S. federal environment looks like politically. And that will it will be that will decide elections for Congress in Ohio, not the districts themselves.
But using Senator Brown, using a presidential or Senate race as opposed to including the congressional seats, it's a little skewed, right? I mean, we're talking about 2 statewide as opposed to district-wide.
Your Honor, races. No, I'm sorry, Your Honor, that's a fair point, and that point is hotly debated. Nobody agrees on what data to use. Nobody agrees on what data to use. It's hard to use congressional district data because the districts are changing. So it's hard to make an apples to apples comparison. It's much easier to use the statewide data. And for the record, Mr. DeRossi testified that he only used the FEDEA, the FEDEA data in drawing these districts. He did that because their federal elections seemed appropriate. Could reasonable people disagree? Of course they could. That doesn't make the map unconstitutional beyond a reasonable doubt. Mr. DeRossi he still had the data from the legislative process on his computer. That certainly makes sense. Why would he delete that data in view of the ongoing litigation? But he testified he didn't use that, he didn't need it. And so he scored it the way he did. Interestingly, if you score the enacted districts using the data that the Democrats were using, even there are 5 competitive districts compared to 5 competitive districts in the Democrats' plan. So by every measure, using whatever data you want, the enacted plan either beats or ties the other maps that were before the General Assembly on the number of competitive districts. And we think that's important.
Couldn't Mr. DeRossi or Mr. Springhetti have taken just the statewide vote on the congressional districts, which happen every 2 years, and said, okay, there were this many Republican votes for members of Congress and this many Democratic votes for members of Congress, without the district lines being involved, and included that in the data, so that we, because Mr. DeRossi's rationale was, let's just look at federal elections. And so why would you not include the congressional? Because you could do it without regard to district lines.
Your Honor, that might be a fair idea. That might be a fair thing to think about. I don't think it would have changed the analysis very much. And I think some people might criticize using congressional election results or data without regard to the lines. I think some people could fairly criticize that, because otherwise you're just simply taking congressional election results and sort of aggregating them up to the state level. And I don't know if the political science would support that, but in any event, I think it just shows, to me, it underscores the point that there's literally 1,000 different ways to do this. And no one's going to be 100% correct all the time. That's why Ohio law and this court's jurisprudence gives the General Assembly discretion, particularly when you have vague terms like this. They give the General Assembly discretion to decide reasonably. They don't get to do anything they want. They get to decide reasonably whether or not, how to interpret and how to deal with these very difficult concepts in a very difficult task of redistricting. It's inherently political. It's hard. Everybody is interested in it, and so the Ohio Constitution quite wisely gives the General Assembly or the Commission, depending on who's drawing the districts, the discretion to decide how to deal with these very difficult issues, including the issue of what data do we use. Now, I would also point out the Ohio Constitution says that the General Assembly has to explain how it didn't unduly favor or disfavor a party or its incumbents, and they did so here. And that's sort of a check on the General Assembly. It's like, okay, you're not going to just be able to pass a plan. You're going to have to explain how it complies with the Constitution.
But the explanation really simply was that it's more fair, or not as unfair, or not as gerrymandered as the one that was in the revised code, 3521.
Your Honor, let me clarify that. So the statement as to the unduly favor or disfavor relied on the fact that it drew 7 competitive districts.
Okay.
It did look back to the 2011 plan on compactness.
Well, 7 more competitive districts, more competitive than they were prior to the drawing.
That's correct. There were only 2 competitive districts, I think, in the last plan, and this one has 7. And so that was pointed to as not unduly favoring or disfavoring a party or its incumbents. And I would also, I'm sorry.
I was just saying, do we look at how much competitive it was drawn, how much more competitive that these additional districts were drawn, as in slightly more so? Is there some measure that we can look at for that?
There were only two. I couldn't point you to a place in the record where that exists. It could be found out by looking at the deriving the political lean of those districts versus the ones now. But I think it's fair to say that the 7 competitive districts that are in the current map are much more competitive than the corresponding districts in the 2011 plan. I think that would be a fair statement to make.
Okay,
So why would we use that as the starting point, the 2011 map, when clearly the intervening factor was the vote of the people that, demanded that you scrap that kind of analysis and you go with your guidepost is not to unduly gerrymander the elected maps. So to say, well, this map is more competitive than the 2011 map, when clearly the 2011 map was unsatisfactory. So why use that as your starting point and not just scrap everything and start over from scratch?
Well, Your Honor, they did, in fact. I'm just making the point that if you do compare it to that plan, which has been criticized but was never overruled, that if you look at that plan, that it's clearly.
Council, didn't the people overrule it? I mean, it maybe not overruled, in front of us or another court, but the people in their vote overruled what had been done up to that point, did they not?
Your Honor, the way I would answer that is to say the people said they wanted less partisan districts, and that's exactly what they got. I don't know if they were thinking back to the 2011 plan. I will say this, if they were, it would have been very easy for the General Assembly and the people to have put language, very specific language, to say you have to have proportional representation. I mean, they could have been very clear about that. They didn't. So that would seem to suggest they weren't really thinking about the 2011 plan necessarily. But what my point is, they clearly said they want less partisan redistricting in Congress, and that is exactly what they received in a plan that has more competitive districts than potentially any in history, and certainly in recent history, that can flip back and forth and that are fair for all the citizens of Ohio. And Your Honor, I see that my time is expiring. If there's no other questions, I will be seated.
I just have one.
Oh, yes, ma'am.
Other states have adopted other standards of proof or burdens of proof. Missouri, Florida, Pennsylvania, Maryland. Florida says it's not beyond a reasonable doubt. It's whether the plan is facially consistent with the Constitution's requirements. And if it's found to be facially inconsistent, then there's less deference then, and essentially the burden shifts to the legislature to justify its plan with no deference. So, I mean, why would we need to, in light of what the chief just asked you, the Wilson case is based on what the Constitution was before the voters said we don't like the current system. Why should we be stuck with beyond a reasonable doubt, which was the Wilson standard of proof, when the voters said, hey, let's go in a new direction?
Well, to do that, I think this court would have to overrule Wilson, which I think would be a pretty drastic step for it to take. The beyond the reasonable doubt standard is also very consistent with this court's constitutional jurisprudence in other areas. And so I think that would be a very drastic. The people in amending the Constitution said nothing about the burden of proof. They may have in other states. They didn't say, and those other states may very well have adopted provisions to shift the burden of proof and have that, that kind of a system. The people in Ohio didn't do that. They voted on that knowing that Wilson v. Kasich said that beyond a reasonable doubt is the standard. And so we believe the court should stick with what the court adopted and what the people have seemingly ratified or affirmed in the amendments.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Strack. All right, Mr. Stafford, you've used your time. You may take 2 minutes.
Thank you, Your Honor. The 2011,
Would you start with the burden of proof that we just ended the last conversation with?
certainly, it's our view that the beyond a reasonable doubt standard is inappropriate here. In the usual case, the court is testing a piece of legislation against some broad constitutional provision on appellate review. By contrast, Article 19 gives this court original jurisdiction and a non-discretionary rule of decision. In essence, the voters wrote constitutional instructions into the Constitution about how the General Assembly must draw districts with some specific shall nots. In that case, a beyond a reasonable doubt posture, or standard of review rather, is an inappropriately deferential standard of review. That's what the Florida Supreme Court determined in reviewing its own very analogous constitutional provision. And so we believe that beyond a reasonable doubt is unduly deferential. Now, in the ordinary course, the court does apply a presumption of constitutionality to legislation. Any such presumption that might be applied here should be done with muted force, given the constitutional restrictions on the General Assembly's discretion when it passes a simple majority map. And any such presumption would be rebutted here because the plan does unduly favor a political party. And thus it is in direct conflict with the Constitution in much the way, Justice Bruner, you were describing how other courts have analyzed their own similar provisions here. The 2011 plan was struck down by a federal district court as a partisan gerrymander prior to the Rucho decision. The efficiency gap of that plan was 11%. The efficiency gap of this plan is about 23%. It's worse. Their own evidence, HC 760, shows the Princeton University gerrymandering project giving this plan an F for partisan fairness. We don't need to look at Relator's evidentiary submission. The 2011 constitutional standard is undue favoritism, not competitive.
Let me ask you real quick, Mr. Schreck saying the General Assembly didn't have anything else before them. They had the plans that they had, and out of the plans they had, the one that was adopted was the best plan, or the least partisan plan. Well, how do you respond to that?
First and foremost, the issue is not comparative. The issue is their compliance with the Constitution, not how it measured up to what other caucus plans suggested, by the way. And also, if we take a look at the measure of competitiveness that they proffer in Dr. Barber's own report, the caucus plans offered by the Democrats have the same number of competitive districts as under their own proposal, yet for some reason the General Assembly didn't even consider those proposals. And there's a reason for that, because if we look at Dr. Warshaw's analysis, the supposedly competitive districts all skew Republican. If you look at page 24 of Dr. Warshaw's report, he shows that. So competitiveness and partisan fairness are not the same concept. The court recognizes that at paragraph 14 of the Wilson decision. So if Ohio State every year has to spot Michigan a 2-touchdown lead, it might make the game more competitive. The rules are set up to favor one team over the other. And that's exactly what they've done here with their supposedly competitive districts.
Thank you.
Thank you.
Thank you. We'll take the matter under advisement and you'll be notified of our decision. Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.